is First of Its Kind, the show that will feature inventions and inventors from all walks of life, creating ingenious products and services that solve problems, save time, and save money. Hello and welcome. I am Nike Oyebanjo. If you've ever had an idea for an invention and wondered about the first thing to do, this is the episode to watch. Our guest today is Adia Coleman, a patent and trademark specialist at the Howard University Founders Library. Ms. Coleman will take us on the step-by-step process on how to obtain a patent for your invention. If you plan to market your idea but cannot afford to do so, do not lose hope. There is help. Ms. Coleman will tell us more. Ms. Coleman, it's great to have you here with us.
Thank you so much for having me.
Briefly tell us what you do as a patent specialist.
Well, first and foremost, I'm a librarian at Howard University and Founders Library. Howard University is also a patent and trademark resource center. We're one of 84 resource centers nationwide. They're strategically placed geographically so that not everyone will have the opportunity to come to Alexandria to the USPTO.
And that's the headquarters.
Exactly. And so we're strategically placed in the States where we're trying to just be a local resource for those who have inventions. And so at Howard University, we err on the side of making sure that innovation, creativity, and entrepreneurship are a pervasive element on campus. So we help faculty, students, staff, but we also help the community members. We don't turn anyone away.
Now the USPTO, that's the United States Patents and Trademark Office.
That's right.
Howard University's Patent and Trademark Resource Center is affiliated with them.
Absolutely. We do research day in and day out. We're the best resource to get people started with the process.
Great. Now, what's the first thing an inventor should do when they have that bright idea?
There's a lot of guides out there that help people start the process. I've simplified the process for my patrons in 3 steps. There is, however, a Patent and Trademark Resource Center guide that's called the 7-Step Strategy. This guide is found online at www.uspto.gov. But I can speak to a shorter version of the 3-step process that I've coined. The first is assessment. You have to figure out what your idea is. Is it a device? Is it a process? Is it an ornamental design? Once you've figured that out, you need to brainstorm, and this is also part of the assessment, still in step 1. You're brainstorming different keywords that could describe your invention or idea. So for instance, if your invention is a chair, you might also want to have at least 10 to 15 different keywords or synonyms that would describe the chair. Then you want to go into describing the physical makeup or the physical composition of the chair. Again, if it's not a chair or if it's not a device, then you might want to describe the process that it took to get your idea on paper. Once you've finished the assessment piece, you need to figure out, still in assessment, you need to figure out whether you're going to have a utility patent, a plant patent, or a design patent. There are 3 types of patents. The utility patent is basically what you're doing to have it be used. Is this idea going to be used in commerce? A design patent is an ornamental feature of something that's already been created. A plant patent is actually very interesting, but one of my favorite apples is a Honeycrisp apple.
I love it too.
Yes, it's very crispy. It takes the color from a red delicious apple and a Granny Smith apple, and it combines the 2. But these plant patents have to be asexually reproduced, and if you can do that, then you can be granted a plant patent.
There are lots of people who know absolutely nothing about patents.
Right.
They want to be sure that no one else No one else has that idea.
And that's where we come to step 2, which is discovery. And that is why the PTRC, the Patent and Trademark Resource Center, in all of these different areas, there's one at Howard, I would be the specialist, and there's another at the University of Maryland. We come in stage 2. Stage 2 is discovery. You're trying to figure out if your idea has already been created. Of course, the Patent Office has been established in 1790, so I'm sure there might be something similar to your idea. That's where I come in as the specialist to help you figure out where to look in order to find out if your invention has been done. If it has been done, but your idea still has a non-obvious improvement upon the already granted patent, then there's still an area. There's a lot of gray areas, but there's workarounds. You'll be able to go around that.
So I come to you with my idea, and we have to do a patent search.
Right.
You know, and what I've heard, it could be very, very tedious. How do you help me as a person with this idea?
Well, I use a generic example, and I go through this process from beginning to end, meaning I'm brainstorming keywords to describe. I use an animal bowl for feeding water. It's actually a video that's on the USPTO, so I don't stray far. And the reason why I use this same example is because if someone leaves me and goes home and tries to mimic the search, I don't want them to feel lost. I want them to be able to simulate the search that we just conducted in the past hour. And the animal feeding bowl is actually heated up. It could be heated up during the winter, and it can be cooled off during the summer. And so I use a generic example. I do that for many reasons. One of the reasons is also because a lot of people don't feel comfortable disclosing their information, and they shouldn't. So they shouldn't have to. So I use a generic example. We go through the process, and we use the patent classification system. We use the cooperative patent classification system, and those two systems allow people to begin to understand how these patents are even organized. There are over 800 classes within the patent system, and so you have to figure out the closest class that your invention would be under.
How important is a patent attorney?
Well, let me say that as a Patent and Trademark Resource Center, we cannot give legal advice. So I'm only here to help you conduct the search, and emphasis on help. I can't do the search for you either. I can provide you the tools, and I can equip you with the confidence and the wherewithal to navigate the system. That's the website and the databases, but I can't do it for you, and I can't give legal advice once you find something close. Patent attorneys are registered legal experts that have already registered with the United States Patent and Trademark Office. And so they're already out there with the expertise to help you. A cost does incur, but all of this is done either with a patent attorney or pro se. That's a legal term meaning on your own. So if I do my job and give you the confidence and the self-esteem to search for these things on your own, and you feel confident that you found something that you can apply for, then by all means you can do it pro se.
On the USPTO website, I do see that they suggest pro bono services for people who cannot afford a patent attorney.
Absolutely. There's a couple of states that have pro bono projects. There's the Howard University School of Law that has a trademark clinic. Now, it's not a patent clinic, but there is a trademark clinic. The Howard University School of Law also does have a professor that teaches intellectual property. And so there's a lot of resources. There's a lot of law firms that you can search for by doing a simple search. And I can also help you with that. other patent and trademark resource centers can help with that. And that's why we changed our name from Patent and Trademark Depository Library to Patent and Trademark Resource Center. We are our own resource, but we're connecting you to other resources. And so if my job for that particular patron is to help find or locate a lawyer that's going to do this pro bono, then by all means I'll do it.
Okay. We've been saying the word patent
yes.
several times. For those who might not know, what is a patent and why should an inventor get one?
A patent is a particular type of protection on an idea or invention. It's protection. The United States Patent and Trademark Office is under the Department of Commerce, meaning most of these inventions are used in commerce, and they're used to exchange, money for goods and services. So you would have to protect your idea in order to get a leg up on the competition. Nowadays, you do not have to patent something in order to produce it, but if you are worried about protecting something later on down the line, you might want to invest. It's an investment. The same way you want to get homeowners insurance for your house just if anything goes wrong. People are thinking of ideas all the time, and there's nothing new under the sun. You cannot reinvent the wheel. So
absolutely,
you can make a non-obvious improvement on a patent or an idea that's already been out there. Once you do, it's up to you to protect it. If you want the protection, if you don't want someone to use and make money off of your idea, then it's highly suggested to protect. The other thing is patents have different terms. So a utility patent and a plant patent have a term of 20 years. That's enough to, I'm older than 20, but 20 years ago, that protection lasted a long time, and enough to deter the competition for even trying to go forward with the idea.
That's when you get the patent.
Exactly.
Now, before that stage, I've done the patent search.
Yes.
And I see that, wow, it seems like I'm the only one with the idea. What do I do next?
You have to check, because we're a global economy now, you have to check not only the United States patent holdings, but you also have to check foreign patents.
That's an important point.
Absolutely. Again, you don't have to protect your invention in foreign countries, but you do have to search it. Because of the fact that we are a global economy, there are foreign patents that have been given protection in the United States. And so you might be rejected, even if no one has done anything in the United States similar to your idea. You will be rejected along the lines. So again, the Patent and Trademark Resource Center comes into play because we're trying to save you money. If you file for the patent but get rejected, you would have wasted money when you could have come to me and we could have worked on searching for foreign patents.
So you search worldwide. So every patent issued by the USPTO is like you are the first person in the world to invent that idea.
Yes. So there's the America Invents Act. That changed the game in terms of, there was a paradigm shift in terms of putting an application on file. So it used to be that if you were the first to invent, you would be granted some sort of grace period to get all of your ducks in a row so that you can contest someone patenting your idea. Now, with American Invents Act, it's the first to file. So again, I can't give legal advice, but what I can say is there are two types of applications. There's a provisional application for patents, and there's a non-provisional application. What the provisional application does is, first of all, it's a lower fee. Second of all, it puts the fact that you have invented something on file.
Provisional application is like how much?
I want to say, after everything is said and done, off the top of my head, $150.
Okay.
Around, give or take, depending on how many claims you want to give. But the provisional application puts puts the USPTO on notice that you are in the process of completing all of the details going into this invention. You don't have to do the drawings, you don't have to do claims. All you have to do is apply and say, this is my idea, and here's a description of it. It gives you 1 year to hammer out all the details, and it also gives you the patent pending status. So you have 1 year to the date of the application to maybe work with someone who's a technical person if your patent or your invention is a utility patent.
Examples of utility patents, please.
An example of a utility patent would be the washing machine, a hammer. An example of a utility of a design patent in terms of the hammer would be maybe the rubber part of the handle of the hammer to make for an easier grip. So remember, utility meaning utilitarian, for use. Can I use this? A design patent, is it nice to look at?
Okay, makes sense.
Yes.
All right, so we already did the patent search, the worldwide patent search, and I scaled through.
Yes.
You know, nobody in the entire universe has my idea. It feels like I'm the first person. So what do I do next?
If you are confident enough to file, then please, by all means, go ahead and file. It helps with your local economy, your personal finance, because what you're doing is you're saying, I may not be able to manufacture this, but I have a great idea. I can now sell this. It is a piece of property, and I will eventually own it. And I can now sell this to other companies. There was a patron of mine who had a really good idea. He does have patent pending status, and he is hopefully going to not manufacture this tennis trainer, but he's going to sell it to local department parks and recreation centers. You don't have to create a whole business out of manufacturing, but you can put down on paper that you have this idea and you're ready to make money from the idea.
Interesting. So we've done the search. I'm good to go. I apply.
Yes.
How long does the application process take?
The entire patent process takes about 3 years. That's an average.
It takes about 3 years.
Yes.
For me to get my patent.
Yes. But your application is considered prior art, meaning your application is now searchable, and someone with that same idea still cannot file for the patent because your application is considered now protection.
Oh, that's good.
Yes.
Though I don't have the patent certificate,
That's right.
You know, but it's published that I am the inventor of that idea.
And if you don't have $5,000 to $10,000 sitting in the bank of disposable income, it also gives you time to secure funders. It gives you time to secure possible companies that could purchase your patent. That's called a patent assignee. So you are the inventor, but you're going to eventually assign the patent to someone else. Same way as people buy and sell used cars. I have to hand over the title. I'm the former owner of the car, but I'm now handing over the title to you.
Now you talk about funding.
Yes.
And a lot of people have ideas.
Yes.
But they cannot afford to fund their idea.
Right.
And you just mentioned an assignee, getting an assignee.
That's right.
To help.
So right now at Howard University, and I can't speak for any other university, I can only speak for the one that I work in, but right now at Howard University, we're embarking on something very cutting edge called Innovation, Creativity, and Entrepreneurship, and it's called ICE. We're branding it as ICE. ICE is going to be the place where people can feel comfortable to come and work on their ideas. A business incubator, if you will, but not so much. It's more so as a PTRC, as a Patent and Trademark Resource Center, we're basically just expanding the services to hopefully get the person from ideation to filing to funding. And
that's good.
Yeah, that's what we're working on right now.
Okay, so I get an assignee. I cannot afford to finance my idea. The assignee typically would have terms that I must meet up to before they agree to finance my invention.
Mm-hmm. Yes, but I'm not on the business side of the patent assignments. So.
But you mentioned ICE, and mm-hmm. you said the university helps people, just started the program called ICE.
Yes.
That would help inventors get
not
funds.
Not just inventors. Remember, there's a creative component, there's an entrepreneurial component, and there's an innovative component. And so all three of those components could equal a business plan that could be funded by angels. This initiative is just in the ground stages, but what we're trying to say is that Howard University is not just a college, it's not just a university, it's not just a research intensive institution. We're also making it one that is embedded in the community. And so being embedded in the community, that means becoming a connector, becoming that puzzle piece that connects someone who has an idea to someone who has the funds to support that idea. All we're trying to do is be the liaison between the two.
Okay. Now, there are lots of companies out there that claim to be able to help inventors with their idea, to help inventors bring their ideas to life. Do you have any thoughts on that?
Yeah, my initial thought would be to direct people to the USPTO's website, because there's a list of, or a host of guides that help people decipher what's real
and what's not. And what's a scam.
Absolutely. The other thing is there's an entity that I don't know if everyone has heard of this, but the Better Business Bureau. That's a simple search, typing in a company's name to make sure that they're a viable company. If the company cannot be listed or found on the Better Business Bureau, steer away, steer clear away.
Absolutely, be warned. Getting that patent application,
yes,
that's where the patent examiner comes in.
Absolutely. So even though you're doing your own search, even though you hopefully have used a Patent and Trademark Resource Center locally, and you file, you still will have to pay fees to have the patent examiners do a search for themselves. They're not going to grant a patent based on the fact that you checked off that you did a search. The patent examiner will then do a comprehensive search using databases that are native to the Patent and Trademark Office, and then you'll get a notice in the mail saying your application has moved to the next step. That's the only thing I can speak to, because of the fact that I have not actually gone through the process myself. I'm not a patent holder. But I do know that within as little as 1 to as many as 3 years, you will be notified and have responses and correspondence between you and the inventor and the patent office.
Now I have my patent.
Okay.
And I want to market my product.
Okay.
I want the world to see my product.
Okay.
What advice do you have as to trademarking the name of my product?
Absolutely. I'm glad you asked that, because a lot of people don't understand how the different forms of intellectual property work in tandem. So you have a patent, which is the protection of the invention, but the trademark is kind of the umbrella of that invention. So if you were going to form a business out of this invention, then you need to trademark your business name. That's a totally different process. There's the same way that there are about over 800 classes for patents. There are 50 goods and services that your your business would fall under through the trademark process. So what you would have to do, again, is start the process all over. Do the search, do the assessment, do the discovery, and then file.
So you can do all this on the uspto.gov.
Yes, absolutely.
Okay, let's talk about trademark names.
Okay.
There's been a lot of talk about the Washington Redskins name being insulting to Native Americans. The USPTO canceled the trademark for the Washington Redskins.
That's right.
Does the USPTO have a guideline on the appropriate names for inventions?
As a native Washingtonian, I've been following this case really closely, because there are a lot of litigation toolkits that are out there for trademark owners or business owners. There's one particular guide under the Trademark Trial and Appeals Board, the TTAB. This board is basically an administrative board that will decide cases based on opposing parties, what they're trying to, you know, protest. The trademark office tries their hardest to have people be proactive. That means you need to be actively looking around and finding out if your trademark name is affecting any other community, if it's affecting any other business, if you're going to potentially be sued. You have to be proactive, and it seems as if the Redskins name was not proactive enough, you know, to.
Well, I think they've had that name for so many years now.
They have.
So why the hula about it?
Well, even though they were granted the name, that doesn't mean that it was actually opposed the day probably within the same year of having the name. It was probably opposed during that year. So this is a long time coming. Yeah.
Ms. Coleman, it's been great talking to you. Thank you so much for joining us.
Thank you so much for the opportunity.
For joining us today.
Thank you.
I hope this show answers all of your questions on the first steps to take when you have that bright idea flash. For any questions, comments, or suggestions, please send us an email, info@firstofitskind.com. We look forward to hearing from you. Thank you for tuning in.